Again, we've allotted 15 minutes to the side. We're ready when y'all are.
Thank you, Your Honor. May it please the Court. My name is Ray Poole. I'm with the firm of Constangi, Brooks & Smith in Jacksonville. We're here on behalf of the appellant in this interlocutory appeal, which is also the plaintiff below, Kincaid Coach Lines. And I'd like to reserve 3 minutes, if I may, for rebuttal. An overview of the case, just very briefly, is we're here on interlocutory appeal from an order of the Circuit Court in Bay County partially denying Kincaid's motion for preliminary injunctive relief. Kincaid below in the complaint has raised a number of claims, but for purposes of this appeal, the only claims that are at issue are the claims under the Florida Uniform Trade Secrets Act and also for tortious interference. By way of description, Kincaid is a charter bus company. They provide charter bus services for both public and private entities and also provide tour services. They're headquartered in the Midwest, but then they've got various offices located throughout, including one in Panama City Beach. The appellees, Ms. Van Pay, worked for Kincaid as its terminal manager in the Panama City Beach location, and in that capacity, she essentially ran the whole shop, if you will. Mr. Dionne, who is Ms. Van Pay's brother, was a dispatcher at the Panama City Beach location, and Faith Aulis, who is a defendant and appellee here, is the mother of these two adult children, was the tour director. The other party I'd like to mention is Coastal Coaches. What happened ultimately is these three defendants left Kincaid without any advance warning and went down the street and began working for a brand new company, Coastal Coaches, which also provides charter bus services and tours. By way of chronology, what happened is...
Mr. Poole, didn't
yes,
they
sir.
actually form the new company? Didn't they actually form
That's correct. And what happened is this. Back in the 80s, it appears that Jerry and Faith Aulis started a tour bus company, which they eventually sold, and it went through a couple of changes of ownership, and ultimately Kincaid purchased that. Throughout those years, the location remained the same, and the personnel remained the same. Jerry Aulis continued to work there. Faith Aulis continued to be the tour director. And Ms. Van Pay continued to work there and ultimately became the terminal manager. Then what happened in June of 2009, there was a gentleman named Jimmy or J.D. Wilson who was a bus driver at Kincaid, and we have an email between Mr. Wilson, Ms. Van Pay, and a third party discussing the name of a new company, which ultimately became Coastal Coaches. And at that point, on June 11th of 2009, they're talking about what to name this new company. Now, interestingly enough, what happened that very same day is Ms. Van Pay's brother, Mr. Dionne, inserts a disc, a CD, into his work computer at Kincaid, downloads a bunch of Kincaid material onto that disc. He dates the disc June 11th, so there's no question that coincided with the email about naming the company. Then once he downloaded the material on the disc, he wiped the computer. He deleted the information off the computer, including all but one email. Fast forward a month, Ms. Van Pay and Mr. Wilson are continuing to have discussions about forming Coastal Coaches, and that's happening in late July of 2009. During that time, Mr. Dionne, on July 20th, 2009, emails an entire safety packet. And basically what happened is Kincaid prepared someone in Kansas a safety packet for drivers to complete in the event of an accident. And then they forwarded it to headquarters. Now, although he had no responsibilities for filling out those documents when he was at Kincaid, he emailed that to his personal email account. Now at Coastal, he's in charge of safety. He also, on the 24th of July, emailed himself an entire packet of personnel forms for Kincaid. Now, at Kincaid, he had no responsibility whatsoever for personnel matters. At Coastal, he does. August 3rd, and this is, I think, the most critical and what I'd like to focus on. Yes, sir.
Before you tell us this last one, let me make sure I understand to which claim this is relevant. Is this relevant to the interference with a business relationship claim or the trade secrets claim, or both?
Both.
Because it doesn't all of this stuff have to be of some intrinsic value for trade secret purposes, at least? And
that's correct. And, Your Honor, and candidly, some of these materials don't have, I don't believe, what qualifies a trade secret. And we're not contending that, for example, an IRS W-4 form for a new employee to fill out would constitute a trade secret. Certainly not. What we are saying, number one, is it forms a picture of these people acting in concert, taking some material which was a trade secret. And in the answer brief...
There's really very little question that they were acting in concert.
Yes, sir.
I mean, it seems to me that you're not going to get an injunction for interference with a business relationship. At least you're not going to get a temporary injunction. It just virtually never happens. So to get one, you have to rely on the trade secret issue. So let's talk about which of these documents constituted trade secrets and why.
Okay. Some of the material that Mr. Dionne downloaded onto that CD, and there was argument about whether we produced a customer list. Now, I'd also point out that customer lists are far from the only thing that would constitute a trade secret in Florida. But some of the material that was downloaded onto that CD was, in fact, a list of people who had signed up for a cruise through the tour part of the business, which we discussed in our brief, that Ms. Aulis had gotten together for, we thought, Kincaid, but she pocketed the money. There was a list of individuals who had signed up for that cruise on Carnival Cruise Lines. That was part of the information that was downloaded onto that CD. That would be a discrete list, and I understand, Your Honor, that there are a number of cases that talk about customer lists, and the question is, you know, how publicly available is the...
But you won on that issue, didn't you? Didn't the court enjoin the use of that list?
The court enjoined the use of the name Professional Yours.
It didn't also enjoin use of the list?
I don't believe that was the case. The other thing that I wanted to focus on, I think that the most obvious example of the trade secret would be the emails that Ms. Van Pay sent to herself. And what happened was twofold. There are two types of emails from customers. One, Kincaid has an internet site onto which customers can post an inquiry about a potential pricing for a trip for charter bus services. That is then forwarded from Kansas to the various terminals, depending upon which one is the most appropriate. Ms. Van Pay got a number of those emails, which she then forwarded to her personal email account. And then what we find is that she then contacted, the day that they left, or right after they left, contact those individuals or entities on behalf of Coastal Coaches and book trips. The other type of email is not the one that came through the internet site, but from customers or specific prospective customers to Ms. Van Pay directly. And in those, I believe there were a total of about 16 of these emails that she forwarded to her personal email account and then utilized to book these trips. Now, some of these emails, Your Honor, were inquiries about cost. Can you give me an idea how much it'll cost to go to the Macy's Day Parade in November? That sort of thing.
Wasn't there testimony, Mr. Poole, to the effect that these people who were looking for charter bus services would routinely inquire of all of the companies in the area that provide those kinds of services?
Well, there may be speculation and self-serving speculation about what a discrete group of people might do. But what we know is this, that we've got particular people who are making specific inquiries. And another example would be those who not only ask for a price, but I believe Little Zion Church said, go ahead and reserve the buses. We need to get a contract right away. And so there we've gone beyond a mere inquiry about a price into a request for booking the charter itself. And so those individuals, the question is that publicly known, that email request? And we would submit that's not. That's a hot sales lead. Does it have economic value? Absolutely. Everyone would love to know that they've got a potential customer who on a particular day at a particular time has a particular need for a certain size bus or a number of buses to go to a particular place. And that certainly has economic value to Kincaid. And we cited, candidly, we didn't find any Florida opinions that specifically dealt with customer sales leads or customer inquiries.
What about the Thomas v. Alloy Fasteners case? It seems to me that dealt with customer lists.
We found, let me, I apologize, Your Honor, that one, I'm drawing a blank on the Alloy Fastener case, but we certainly found some cases out of the U.S. District Court of Ohio, Colorado, and Kansas where a similar uniform act was enacted, and the courts in those cases said that customer leads are protectable trade secrets. The U.S. District Court in Colorado said, in fact, is a classic example of a trade secret.
In this case, though, the court specifically found that you had failed to introduce a customer list or to demonstrate that you all had contributed to the creation of a customer list.
Well, that's difficult. Looking back at the order, and this goes to our argument on the standard of review, is that it's difficult to discern from the order because there are no factual findings in the order. It appears to be purely legal conclusions. You haven't presented evidence of misappropriation of a trade secret. And for that reason, the review would be de novo. Thank you.
Or would it,
yes,
if it seems to me that's classically factual findings?
Well, Your Honor, we've got some examples. I think that this would, first of all, where an order contains no findings of fact. There were no discrete findings of fact in the order. United Healthcare versus Brown addresses that, and in that instance, the review is de novo. Where it's an application of historical facts to the law, that's a de novo review. And I know Judge Webster and Judge Davis, you were on the panel for Gainesville Healthcare versus Weston, where that was the standard of review utilized in that case, de novo, because you're dealing with an application of facts to law. Here, at most, we've got 2 sentences on the trade secrets claim. No separate findings of fact, just a conclusion that there's been no misappropriation of trade secret information. Thank you. I'll reserve.
But wasn't there a factual conflict about the misappropriation in that I think it was Van Pay testified that she didn't misappropriate anything?
Well, Your Honor, we would submit quite the opposite. There is no issue because there is no question that these individuals emailed stuff to their personal accounts. There's no question about that whatsoever. There's no question that Mr. Dionne burned a CD, which on Sunday night, the night before he left without notice, he went into the office and took, along with the other 2, took their information, and I think their testimony was cleaned out the desk. So I think actually the testimony is uncontroverted, or the evidence is uncontroverted, that there was a taking of information here. They admit that. Thank you.
You've got about a minute and a half left.
Yes, sir.
May it please the Court. My name is John Durr. I'm with the firm of Quinteros, Preto, Wood, and Boyer, PA. based here in Tallahassee, Florida. I have the privilege of representing the appellants, Debbie Van Pay, Rick Dionne, and Faith Aulis. I also represented in the trial court below Coastal Coaches. I want to answer a couple of questions that were addressed at the close of the appellant's argument. One of those is the copying of the CD. The testimony with respect to the CD was that Mr. Dionne was trained in the military, in the Navy specifically, and that it was his training and custom to remove old files from a computer, burn those onto CD so they wouldn't be lost, and retain them, and then delete them from the computer in order to make it function better. He testified that he kept that CD in his desk drawer, and that he did not use the CD either after he initially downloaded it or after he left Kincaid. And it was returned to the company, and they do have that CD. So that's with respect to the CD. With respect to the customer sales leads, there were 16 emails which Debbie Van Pay sent to her home address sometime within the last 2 weeks that she was with the company. However, she testified that she had either followed up on those leads during the time she was with the company in terms of sending out the information that was requested, or that she didn't remember one way or the other whether she had or not. Some of those, perhaps one or two of those, subsequently entered into contracts with Coastal Coaches, but it's not real clear from the testimony how many of them did. It certainly wasn't all 16. The court did make...
But counsel, so it is undisputed that some of the, for example, individuals or companies who made contact with the internet site, some of the identity of some of those was emailed by the appellees, and they followed up on those contacts.
Eventually, I think that's probably true of one or two.
But why, even if it's one or two, why isn't that a trade secret, a violation of the Trade Secret Act?
Thank you. That's a very good question, and there are a couple of answers to that. The first answer is that an email from somebody outside the company can't be a trade secret as to the company. It might be a sales lead, and it might have value, but it can't be the company's trade secret because the company hasn't done anything to it. Secondly, it's not...
Wait, I'm not sure I understand. So if an appellee, while employed by the appellant, sends an email to their personal email address, the information in that email can't be a trade secret? Is that what you were saying?
No, sir. The email, under certain circumstances, it could. But where what you're dealing with is simply an inquiry from a potential customer that says to, in this case, Ms. Van Pay, how much would it cost me to lease a bus for my team to go to the next football game? And Ms. Van Pay responds to that, or doesn't respond to that, but keeps that lead in her own mind and goes back and subsequently sells to those people. That's not a trade secret under the trade secret statute, because the statute requires that the company add some value to the information which it possesses.
But what about the case of the information obtained from the internet site of the company? Not a direct contact with Ms. Van Pay. It wasn't in her head. She removes that information from the internet site or takes it, sends it to her own email address, and then pursues those individuals. Clearly, it's the company's internet site. They've invested in the internet site. It's password protected. Why isn't that a trade secret?
No. I'm sorry, Your Honor. Not the company's internal intranet. That's not what we're talking about here. What we're talking about is a public internet site where customers or potential customers can obtain pricing information.
So it's not the internet site of Kincaid.
Correct.
It was a public internet site where anyone can access and obtain the people who want to bid on a bus.
Correct. And that information would have gone to presumably Kincaid headquarters, perhaps directly to Ms. Van Pay. It depends on the software. But that's what they were talking about, was a internet site, not an intranet site.
Well, now, you've lost me now. I understood this was a Kincaid internet site where prospective customers could log on and seek information regarding pricing. Is that not what it was?
Let me see if I can explain it this way. The testimony that occurred in the hearings, there were 2 of them, over 2 days, is that the only internet site that was specifically identified was an internet site by a trade group that contains the names of many coach companies that customers can pick from to obtain pricing information.
So all of these coach companies had submitted pricing information in advance to this trade company.
I don't think that's the way it works,
Well,
Your
no,
Honor.
the way it probably works is the trade company routes that inquiry to whatever company it's directed to, isn't it?
I think that's correct.
And why wouldn't that become confidential information at the point when it was received by the company to which it was routed?
It may very well be confidential. There is a distinction in the case law and in the statute, Your Honor, between confidential information and trade secret protected information.
And they were seeking an injunction only based on trade secrets?
That would be one answer to...
And covenant not to compete, because that's where they would say that this information wouldn't be able to be disclosed, but they didn't have a written agreement in the end.
Yes, Your Honor,
But
thank you.
originally they sued on covenant not to compete as well.
That is exactly
and
correct.
used the company's information of a customer list that may
Yes.
not be a trade secret, but would be part of the company's outside. I mean, you wouldn't be able to, you'd violate the covenant not to compete if you use that list.
That's exactly correct, Your Honor, and that's the distinction that I should have made myself, and I appreciate the question. The distinction is that confidential information can be protected by a company simply by entering into no compete or confidentiality agreements. That was not done in this case. Or it was alleged, but no such agreement was ever produced. Judge Overstreet conducted, as I said, a 2-day evidentiary hearing, and at the conclusion of that hearing, he specifically found findings of fact that there was no piece of information from Kincaid Coast Company that rose to the level of a trade secret.
Did he also find, and did he find it correctly, that the appellant failed to introduce a customer list of any kind?
That's correct. They did not introduce a customer list of any kind. They identified or described a customer list as being all people who ever contacted Kincaid Coach Line for any reason. But there was no identification of a customer list that the company had actually worked on, done something with, or contributed anything to. And in fact, no list itself was ever produced. It was simply described. The judge heard testimony from the CEO of Kincaid. He heard testimony from the Aulis. He heard testimony from independent witnesses, and he examined a number of documents. At the conclusion of that, it was his findings that there was no trade secret and that there was no, that would be entitled to the protection of an injunction. He also found that Ms. Aulis had not appropriately used the Professional Years Tour's name, and he enjoined that. So it's very clear that he was paying attention and that he did make findings of fact at the conclusion of the hearing. There was no attempt made at the hearing below to show that there was anything contained on the CD. That's not in the record, I don't believe, that the CD that Mr. Dionne copied had anything on it. If there was something on it, Mr. Dionne, forgive me, there clearly was something on it. There were files on it, but not a customer listing that would be pertinent to Kincaid. What Mr. Dionne testified that he took off the computer was old Professionally Yours Tours information and old Forever Yours Tours information. Those would have been predecessor companies owned by his parents or by another owner prior to Kincaid. So he testified he took old information off. If there's in fact a customer list from Faith Aulis's, one of Faith Aulis's cruises, It would have been from one of those years, professionally or forever years.
What difference does that make? Didn't Kincaid ultimately buy all of the assets of those predecessor companies?
That's an excellent question, and I think it's an important one. A company does buy all the assets, but it doesn't buy the customers. One of the distinctions that's made in the case law is that a customer list is protected. The information on the customer list, especially proprietary information, is protected, but the customers are not protected. A business can't protect its customers from being solicited by its former employees in absence of a no-compete agreement or in absence of a no-solicitation agreement.
But as you said, the lists are, and it seems to me the test there would be, would any of these individuals have had knowledge of individual customers, absent material obtained from the files of Kincaid?
Yes, Your Honor, that's another excellent question. I think we discussed that in one of the cases in our brief, is that if the employee has information or has knowledge of the customers through his or her own effort, then he or she can go ahead and compete with the employer for those former customers unless there's a no-compete agreement or a confidentiality agreement.
But does the record reflect that any of the individual customers here were customers that would not have been or were not known by the appellees?
To my knowledge, it does not, Your Honor. I don't recall any testimony like that. I don't believe it's in the transcript. There was also an allegation below, and there was an attempt at proving, to some extent I suspect, that pricing information was of confidential nature or was important to Kincaid. But the only testimony with respect to pricing was Ms. Van Pay's testimony that she used her own pricing system, one that she had used continuously throughout her experience in the business long before she worked for Kincaid and after she worked for Kincaid. She also testified that each of the terminals of Kincaid, there were either 7 or 8 all told around the country, to her knowledge, used different pricing. And that makes sense if you understand that the main component of the pricing for this leasing of buses is, of course, the diesel fuel and the time of the driver. So you would expect that price to vary from place to place and the formula to change somewhat. It was we discussed the Thompson versus Alloy Fasteners case in our brief. In that case, the court found that the customer list in that particular case was not protected from the standpoint of being a customer list, but was protected because of the pricing information that it had and the profit and loss information that it also contained. In that case, the list, of course, would have had to have been produced and that information made available to the court so that he could make an appropriate decision, or she. Other than the general comment of Mr. Bone that the customer list consisted of all persons who had ever contacted Kincaid, no further effort was made by Kincaid to establish that there was any kind of customer list which possessed any kind of additional information that the company had added to it, any additional work that the company had done with it, any winnowing down like many of the cases that we discussed in our brief, cases where a large customer list had been taken and winnowed down to a narrow customer list that had some value. Nothing like that appears in this record. The testimony was that most of the customers of coach companies in North Florida are public organizations. So if there was pricing information that was available to those public entities, that would, of course, be subject to the public records law and would be available to anybody who wanted it. There was also testimony that these entities were few, not terribly many customers, and all known to the bus companies, at least as far as Ms. Van Pay knew. If there are no further questions, I thank the court for its time.
Thank you. Mr. Poole, you have about a minute and 35 seconds.
Yes, sir. First of all, as to the customer, what was on that CD, that was admitted into evidence as Plaintiff's Exhibit 69. It's a big, thick stack of documents that came right off that CD. That is in evidence. It was admitted in the hearing below. That's where the list of people who went on that Carnival cruise, that's where that list is contained. As for the...
But as I understand
yes,
your opponent's position, it is that because his clients had something to do with generating that information initially, unless it was protected by a non-compete agreement, you're not entitled to an injunction.
Well, and here's the answer to that. Out of the third DCA, Unistar Corporation versus Child, the court said that the law imports into every contract of employment a prohibition against the use of a trade secret by the employer for his or her own benefit and to the detriment of the former employer.
So it depends on whether it was a trade secret or not, as defined in the statute.
That's correct. It goes back to whether or not it's a trade secret. And so there need not be some confidentiality agreement because the law imports that requirement, that duty, to any employee. Number two, we presented the employee handbook for Kincaid, which does contain a confidentiality provision and mandate that no employee use Kincaid's confidential or trade secret information. As for whether or not any of these customers were known to the appellees, the answer is no. Little Zion Baptist Church was brand new, had not done business with Kincaid, and was not known to these appellees at the time that they left. Thank you.
And Zion was, the information about Zion was obtained by Kincaid how?
That was via email to Ms. Van Pay, which she then sent to her home email or personal email account, and then subsequently booked.
You mean Zion emailed Ms. Van Pay?
That's correct. Which she then emailed to her personal email account and then booked with Coastal. Thank you.
Thank you.